in this public forum as it does as it did in the Virginia versus Hicks case from the Supreme Court.
If the council chose to change its code to build in, let's say, a escalator clause so that there's a difference between first disruption and chronic disruption and it's cumulative, do you believe, based on the judge's ruling, that that would have that could have an impact on at least how Judge Simon views this case?
Well, if we were to pursue that course, we would then probably go back and ask Judge Simon to lift the injunction. I do not pretend to be able to read Judge Simon's mind, and I don't know whether he would then believe that we had sufficient protections, whether that would then pass constitutional muster or not, but I do think it would enhance his defensibility if we had to go further to the Ninth Circuit.
And what's your general view on the following question? Under our Constitution, state Constitution, we have a very broadly written First Amendment, and it's quite unique, actually, compared to a lot of other states. Do the federal courts accord more protection for what's purely speech, or for speech that crosses a line into something that's unlawful and therefore constitutional criminal protections of that?
I'm not quite sure I follow the question.
So speech that is not protected speech because
Right.
it involves threats of violence and other
Right.
things is looked at one way by the courts.
Right, that's correct.
Pure speech is looked at another way. Which is entitled to greater protection?
Well, pure speech. I mean, so there's the First Amendment. The courts have interpreted the First Amendment to protect most speech, but there is some speech that historically has been held to be unprotected. Actual threats, primarily clear and present danger, is the test the courts used. Both the federal courts and the Oregon courts recognize that the government can impose some limits on free speech. They analyze them somewhat differently, although I think less differently than they used to. They analyze them somewhat differently, but basically recognize that the government has legitimate interests that sometimes require it to impose limitations of one kind or another on the time, manner, and place in which people speak. But we don't regulate the subject matter of people's speech. We try to avoid all kinds of content-based restrictions.
There doesn't seem to be a claim in this case that any action taken by the city was a pretext for punishing speech, the content of speech. Is that correct?
Right. Mr. Walsh can speak to that himself.
Well, the
but
judge
no.
issued a ruling.
But no, there was no contention of, there was no, the judge found that your ordinance is in fact content neutral.
Thank you.
Are we currently continuing to exclude people who have been threatening to anybody?
I do not know what people are actually doing. I think our advice is not to until we get this clarified, at least under the Title III code.
Does the ruling apply to the city council or to our delegates as well? Because my understanding is, for example, the loss of neighborhood involvement being right by the entrance of City Hall occasionally helps folks who are having some significant difficulties.
No, it applies to the city as a municipal corporation. All of us.
Thank you.
So Harry, just to be clear about the options before us today, we can support this resolution, we can oppose the resolution. We have until January 29th actually to decide the question, so we can continue this discussion if the council wanted to see whether there's a broader consensus around one approach or another. And then there's a related question about whether, linked to this appeal or independently, we want to take a look at revising our code to address some of the concerns that the council has and the court has. Is that correct?
Yes.
If we were to appeal it, would that stay the judge's order?
I believe we would have to move for a stay would certainly do that. I don't know if he would grant one or if the Ninth Circuit would grant one if he denied it. But it would not, I'll go back and double check, but my belief is it would not automatically state.
So I could support some version of this that is amended to talk about clear and present danger, as opposed to what's stated in it right now, which addresses almost entirely speech within the council chamber. I wasn't aware that this decision also applied to the safety of our employees. So at the very least, I'd like to carry it over so that we can work on amending the language that will be appealed to the judge. It's clear that, and I think we need to have some more conversation about and hear from the public in terms of what their view is as to how to keep city employees safe versus their right to make our lives as unpleasant verbally as they would like to do.
I'm interested in that as well. There are two, as this discussion is illustrated, and Dan's remarks highlighted, there are two really separate questions here. One is, how do I or any other presiding officer in this chamber deal with obnoxious behavior in the chamber, in which somebody monopolizes the room for their speech making or otherwise doesn't follow the rules? That's one issue. And there needs to be a process by which people are excluded who are not letting other people speak. That can be episodic, or that can have some duration. That's one question. The other question is, if there are people who need to be excluded because they're dangerous or potentially dangerous, that's a completely separate matter to me. We need to address both. We don't need to necessarily address both with the same ordinance language. So it seems to me that ordinance repair is in order regardless of what we do with this appeal. But that we need to fix our ordinance so that we lay down more clearly, and we'll go defend that once we've debated it, heard from the public, and adopted whatever process we need to operate under in this chamber so that people can be heard and that people aren't rude, obnoxious, or dilatory in taking over the room for their own agenda versus letting us conduct public business and hear from people in some kind of order. That needs to be resolved. The judge has said the way we do that now is not acceptable. Fine, let's fix that. And I don't know whether we have to fix that by going to court or by working on our ordinance. Secondly, if the judge's ruling is so sweeping that it evades the common sense matter of making sure that people that are issuing violent threats aren't routinely allowed into a building that doesn't otherwise have perimeter security, like most government buildings have, then that's a serious problem. And other government agencies respond to that potential threat by having metal detectors and such at their doors, and we, in this city, at least for now, have not. So we got to address that question. And Commissioner Salzman is right to highlight it. It's important, but those are very different matters. And I guess those are my feelings about the issue. I'm interested in having this discussion today, having further discussion at the council level, and then deciding on the resolution. But I'm also interested in getting some work started and some discussion started about our ordinance.
We'll do that.
We might need a better ordinance to defend the court that won't be apparently.
I appreciate your comments, and I appreciate Commissioner Fritz's comments. I had a chance to meet with council yesterday afternoon, and then got some follow-up information. And the thing that I've struggled with is a lack of clarity about what we're approaching in the context of a very important set of questions governed ultimately by the First Amendment. So, just to give you an analogy, if this was not fully baked, but was a routine policy question that came before council, we would all vote just the way we felt about it, and if there's a split vote, so be it. This is a little different. This goes to how we do our business as a body, in which case our general rule is we seek consensus. We seek to find the broadest possible support. Second, ultimately, it's governed under a very high bar, a standard set under the Constitution that Judge Simon addressed. And one of the concerns that I've had is, absent that broader discussion and understanding all the options, with the First Amendment being the touchstone, my inclination would be to vote no if I couldn't be persuaded. So the additional time to find out if we can narrow this or come up with a strategy that gets at the real problem is helpful for me, because my default would be to go the other way, and I'm very appreciative of Commissioner Salzman's comments about safety, public safety, and that's different than pure speech.
Okay, other questions, comments, concerns raised with staff? Let's take testimony.
I just want to thank Commissioner Novi for his defense of city employees. I appreciate that.
Okay, you signed up to speak, please.
6 people signed up. The first 3, these coming up are Ted Walsh, Matt Dos Santos, and Craig Rogers.
Go ahead, Joe.
My name is Joe Walsh. I represent Individuals for Justice, and I am the plaintiff in this case. I am amazed that it was obvious that many of you did not read this decision, because you don't know what the judge said. It's very simple. It's 28 pages long, but it's simple. A politician cannot sit in his office and make a decision to exclude somebody that he doesn't like. That's it. Because if you look at the timeline, when I was thrown out, a week later I was served with the papers. So it's kind of like getting me twice. You throw me out, you threaten me with arrest, and then you exclude me for 60 days. That was arrogant. That was obnoxious. That had nothing to do with people fearing for their safety, Commissioner. There is nothing in the record, and I really resent you saying that. Point to the record. Outside of one person giving testimony to the G4S people,